I wanted to take the opportunity to discuss a recent Illinois state court decision that came out on Friday concerning face mask mandates and vaccine mandates in the state of Illinois. The decision, again, came out on Friday. It was a temporary restraining order against these mandates. And it's a 29-page order. I've read through it. I've taken meticulous notes on it, and because I'm incorporating it into one of the cases I'm handling. And this decision, again, like the New York decision that came out 2-3 weeks ago, in which a New York State court judge issued a stay against a mask mandate over there, this decision is also an extensive, thoughtful, and very analytical evaluation of the authority for these types of mandates by state and local officials. It does what I wish every judge should do when presented with these issues. I've been handling a lot of these cases over the last 2 years, and I've been coming across so many judges who just don't take the time to evaluate the claims and challenges brought against these mandates, and instead they take a very, very lazy approach to trying to understand and analyze and evaluate whether or not these claims lack any merit. In this particular situation, this is a state court case. What happened in this case was, again, like many parents in many other states, this is a group of parents that have just had it with their kids being forcibly masked in school and being forced to quarantine when they've been exposed to someone with the virus, and now they're dealing with vaccine mandates over there. So a group of parents in this case brought a lawsuit against literally everybody in Illinois. By way of background, the decision goes on to explain what the environment has been like in Illinois over the last couple of years. The governor had declared a state of emergency due to COVID in March of 2020, so we're coming on the 2-year anniversary of that. Illinois, like many states, has an emergency powers statute. It's called the Illinois Emergency Management Agency Act. And then pursuant to that declaration, again, like many states, New Hampshire included, Massachusetts, the governor, once they declare a state of emergency, that declaration gives them access to many, many different powers, and they can issue what are called emergency orders to, or whatever you call them, state by state. In New Hampshire, they're called emergency orders. In Illinois, they're called disaster proclamations or executive orders. And the governor can then issue order after order after order addressing many different facets of society, many different parts of the economy, and so on and so forth. So they essentially become like mini legislatures, and they err sometimes on the side of enacting laws, if you will, and it becomes a very dangerous proposition. So in Illinois, the governor after declaring this state of emergency, issued 25 what are called serial disaster proclamations and 99 executive orders related to COVID-19. The plaintiffs in this case were not only parents of students, but teachers working in Illinois schools, and they were challenging 3 specific COVID-related measures enacted by their state officials. Number 1, Executive Order 2021-18, which was an order that school districts require the use of masks for students and teachers who occupy their buildings. The second measure they were challenging is Executive Order 2021-22, which was an order requiring persons who are both unvaccinated from COVID-19 and work in Illinois schools to provide weekly negative results of a COVID test in order to actually come into the building. So this is a vaccinate or test requirement. And this is a very common mandate that many schools and institutions have implemented. I represent one individual in Florida who we sued her. She goes to dental school down there, and we sued that school because they implemented a very similar mandate there, which should be a violation of Governor DeSantis' vaccine passport law in Florida. And so the third COVID measure that this group of plaintiffs challenged was an order that school districts refuse students and teachers admittance to their buildings. So exclude teachers and students from school buildings for a certain period of time if they are exposed to a confirmed or probable COVID case, and if they refuse to test. So this is many schools, for example, in New Hampshire. What they're doing now is if you're exposed to a confirmed COVID case, they just tell you that the Department of Health and Human Services in New Hampshire directs you to monitor your symptoms. They don't automatically exclude you from school until you can produce a negative test. In Illinois, they're being a lot more aggressive about it. So what happened was 2 of these orders provided that state agencies had to promulgate emergency rules in order to effectuate these executive orders by the governor. So the Illinois Department of Public Health and the Illinois State Board of Education, pursuant to that directive, filed emergency rules to effectuate these provisions. So the plaintiffs turned around and sued not only the governor, but the Department of Public Health, the Board of Education, and over 170 Illinois school districts. So they went berserk, which is good. We like to see that kind of energy. It's palpable. It's real. I love that. I love where their heads are at. They asserted the same theory that I've been pushing in all of the cases I've been involved with, and that have shown to be successful. This theory of relief, this claim, has been successful in many cases as of late, and that is the idea that these school districts, these state agencies, the governor, don't have the authority to issue these types of broad health measures. All right? So Illinois is it's a weird state, but they have a set of regulations that many states don't have. They have a set of requirements for quarantine, what's called quarantining people in response to the spread of an infectious disease, and then they also have a concept called modified quarantine. If a department and the authority for quarantining anybody or subjecting someone to what's called a modified quarantine, and I'll define what those are in a second, the authority for those types of measures lies exclusively with the Department of Public Health in Illinois. If an individual is forced to quarantine or subjected to a modified quarantine, they can object, and then they have due process protections. They can then challenge the measure in court and contest it. Now, a quarantine is under Illinois law. Quarantine is what you would normally consider a quarantine. You're supposed to stay at home, this and that. Modified quarantine is a concept that exists in Illinois that doesn't exist in many other states, and that includes less stringent isolation or quarantine measures, and that definition includes wearing a mask. All right? There was a decision in Illinois a few months ago that struck a similar mask mandate issued by a school district because that measure was considered a modified quarantine that only the Department of Public Health had the authority to issue. So now what they're trying to do in Illinois is they're trying to circumvent that. The governor is essentially trying to issue an emergency order, an executive order under the state of emergency declaration. And they're trying to remove those types of protections and issue it under the guise of an emergency and under the guise of protecting the public safety. This decision, this 29-page order is really, really good because the judge takes the time to go through these measures and search for and identify the specific authority and where it exists for the governor's actions, for the department's actions. And the court takes the time to acknowledge that there has been a tragic toll, and I'm going to read straight from the order. The court acknowledges the tragic toll the COVID-19 pandemic has taken not only on this state but throughout the nation and globe. Nonetheless, it is the duty of the courts to preserve the rule of law and ensure that all branches of government act within the bounds of the authority granted under the Constitution. There is no doubt that the public has a strong interest in stopping the spread of the virus, but such does not allow our government to act unlawfully even in the pursuit of desirable ends. See, the left has always objected to any challenge to the policies and measures that they want to implement because they rely on the idea that their intentions are pure. You can't question their intentions. Therefore, you can't challenge the substance of whatever policies they want to pursue and implement. But that is an illogical approach. It's an illogical defense of a policy. You are more than permitted to challenge the actual substance of a new rule, a new order, a new policy, a new measure. Simply because one's intentions are pure does not make the policy a good one. Translating that here and applying that analogy here, simply because a governor issues an order to mask kids in schools, or to force kids to get vaccinated to attend school, relying on the notion that it is being done for the sake of public safety does not absolve the governor or the rule or the order that's being implemented of any challenges. It does not ensure that it can survive any challenges. It does not make the policy a good one. So the judge here is acknowledging that. She is, and this is an elected judge. I looked her up. She's a circuit judge in Illinois. Circuit judges in the state are elected, and the judge in New York that issued the decision a few weeks ago, he was also elected. And I'm starting to see a trend here. It's only 2 judges, but judges that are appointed and are not subject to electoral cycles tend to get a little too insulated in their positions, and they tend to get a little bit drunk on the authority that they have. Elected judges know that in order to retain their positions, they need to answer to the people who elected them, and they need to do a good job as judges in order to get reelected. So this is another elected judge who issued this decision. So combing through this decision, there are a couple of things I want to point out and identify. The first is the court explains the Illinois Department of Public Health and its emergency rules. All right. Back in 2014, there was an Ebola outbreak or scare that affected Illinois in some way, and so the Department of Health passed these emergency rules, and they added the definitions of quarantine modified and quarantine isolated. These are the concepts of quarantine and modified quarantine that I alluded to earlier, and that this court decision references. And what's important about the revision to these rules that added these definitions is that the department at the time, and the judge writes, believed that exclusion from school due to a highly infectious or contagious disease was a form of quarantine, subject to the due process procedures as found in the IDPH Act, which is the Illinois Department of Public Health Act, their main statutory scheme that addresses infectious and communicable diseases. So they considered testing, and vaccines as a form of what's called modified quarantine because they were procedures that were, quote, intended to limit disease transmission. So that's why they believed, and they included testing, vaccination, even masking to be a form of modified quarantine. And so under the law, the applicable law, when someone is subjected to one of those measures, a modified quarantine measure, individuals had the right to object to these procedures. If they objected, they were afforded due process of law. Likewise, exclusion from school was also a form of modified quarantine because it was considered a partial limitation on freedom of movement for those who may have been exposed to a contagious disease. At no time, this is key, at no time, the judge writes, did the 2014 emergency amendments take away a person's due process rights. Because you can't do that. A person's due process rights are in the Constitution, the federal Constitution and the state Constitution, and those documents are considered the supreme law of the land. So what Illinois' state officials attempted to do through these emergency rules that they passed in September, just a few months ago, they deleted, and modified these terms. The court writes, subsection D of those rules was added pertaining to schools and added a new provision which delegated authority to the local school districts to require vaccination, masking, and testing of school personnel, in addition to masking for all students regardless of vaccine status, exclusion from school, and testing for unvaccinated, healthy students who were deemed close contacts by the school. They eliminated all of these protections from the rules. Now, you're probably asking or thinking, how can they do that? They can't do it, but they did it anyway. We've seen this. This is one of the many symptoms of this pandemic, of this virus. The most egregious and the most alarming symptom I have observed is government officials doing whatever the hell they want and then leaving us to pick up the pieces. They can't do what they did, but they did it anyway because they don't give a shit. And that forces ordinary people like you, like me, to hold them accountable and hold their feet to the fire. So the judge continues here. The question before this court is whether the governor, under his exclusive authority, can require his agencies to promulgate emergency rules that go beyond what the legislature intended or without utilizing the legislative branch of the government. And that's another way of asking, can the governor essentially create a new law without the consent of the legislature? The answer is no. Let me save you the suspense. So this is where, and if you're watching this, I'm posting this on YouTube. But if you're watching this section of the order, the judge starts to undertake a painstaking analysis of the laws at play here. And the first one is the Emergency Powers Act. The court writes, according to this act, the legislature granted the governor a broad delegation of power. Nobody ever doubts that. No one disputes that having an emergency powers statute is important. There are situations where we have a disaster. Think of Florida and a hurricane hitting the coast of Florida. You do need to undertake certain emergency measures in a very limited period of time to protect the safety of the population. Under that scenario, you do need to have a mechanism whereby the governor or whomever your leader is has access to certain emergency powers and can suspend other rules and laws in order to get people the help that they need. Nobody disputes that some scenario exists where that is necessary and helpful. But the judge notes here that this broad delegation of power under Illinois' emergency powers statute is not absolute. It's not endless. It does not accord the governor limitless power. That's not what it was intended to do. And the judge goes on to explain, why that is so. The court inquired, the judge writes here, at the hearing at the injunction hearing for this case, the judge writes that the court inquired repeatedly as to the emergency that necessitated the emergency rules in September of 2021, the rules that I mentioned earlier, where they removed all these protections from quarantine and modified quarantine procedures. The state defendants responded that now, the court inquired, what's the emergency? Here's how the state defendants responded. They responded that COVID was, quote, fluid, and it was within the agency's discretion to assist the governor and protect the public health and safety. I can't tell you how often that has been the government's response to what's the emergency here? Why are you doing this? Why are you encroaching on people's freedoms in this area or that area? Why are you doing this? The answer is always, well, we're doing this for the public safety, and the situation's fluid, so you need to just defer to us, let us do our job, and leave us alone. That's always the answer. They never respond with any data. They never respond with any concrete or factual justification to support the measures they've undertaken. The judge goes on to note that in the Department of Public Health notice contained in the Illinois Register, they stated that the reasoning was to support schools and school districts in implementing Executive Order 2021-22, which that's the one that requires all school personnel to either vaccinate or undergo weekly testing. They also cited to, other disease reports included with these emergency rules and the General Department of Public Health Act itself. But that isn't enough. It's simply not enough. And it's not lost on this judge that you can't just ignore who has authority and who doesn't. You can't just ignore what statutes say. And the judge notes here on the following page that the executive branch fails to recognize or acknowledge that the legislature granted the Department of Public Health the supreme authority in matters of quarantine and isolation. The court cites a subsection of that law. It states that includes mandatory language, the all-powerful word shall, which requires the governor to coordinate with the Department of Public Health with respect to planning for and responding to public health emergencies. These two statutes must be read together, making it clear the governor cannot make public health decisions during a time of emergency independently and without coordinating with the Department of Public Health. You can't just delegate that authority to the Board of Education and tell school districts that they can do whatever they want in the name of public health without the department that actually has that authority doing something. That would be the Department of Public Health. Here's another one that really infuriates me. A couple of pages later, on page 9 of this order, the state defendants also argue that the governor has unlimited authority to do whatever is necessary. How in the world have we gotten to the point where a government official or a lawyer for a government official can argue with a straight face that a state institution, a state office, whether it's the governor, a state agency, or any other executive branch office, has unlimited authority to do whatever is necessary? That is preposterous. These institutions were created by statutes, and those statutes are specific in the authority that they give them. That does not lend itself to having unlimited authority. They have specific authority in certain areas, and their authority is confined. The power that they have is confined to those areas. They do not have unlimited authority. And for a lawyer to have the straight face to argue this to a judge is beyond me. It's beyond me. The judge goes on to write that if the legislature intended for the governor's powers to be endless, it simply could have deleted all those other paragraphs and said during emergencies declared by the governor is authorized to do whatever is felt necessary without any restrictions. But the statute, of course, does not say that. Lawyering it's not that difficult. It's actually pretty straightforward sometimes. When you apply the law, it's no different than a geometric proof or a math problem, if I were to simplify that. But if you want to know if a government official has the authority to do something, look at the statutes that created that office and see if the statute says they can do what they're doing. If it doesn't say that, then they can't do it. The judge writes here that the legislature never intended for that type of unfettered power. That's absolutely right. That is absolutely correct. All it takes is to look at the statute. The statute does not say, none of these statutes say that these government officials have unlimited authority to do whatever they want. They don't have that. The statutes don't say that. The judge continues. that the Emergency Powers Act makes it clear that the governor does not have the authority to make final decisions on public health, which again illustrates the legislature's intent for the two bodies to work together to come up with framework for health-related emergencies. And this is a doozy right here. The court cannot find, nor did any party provide, any law enacted by the state legislature that grants the IDPH, that's the Department of Public Health, the authority to delegate or transfer its duties and responsibilities to the Board of Education and local school districts. That authority isn't anywhere. The department cannot delegate that authority. They have the authority in public health matters, not school districts. There's a reason for that. It's because school districts are not health boards. Educators don't know anything about public health. If they were supposed to, the statute would have assigned them that responsibility, but it didn't. It placed that responsibility and that authority with a public health department. And the public health department cannot just will away its responsibility in that area to an inexperienced department such as the Board of Education or a local school district. The judge ultimately concludes that the Department of Public Health, in delegating that authority to school districts and to the Board of Education, violated its own administrative rules. The judge continues, the governor's delegated authority regarding masks, identifying close contacts, testing, and vaccines to another executive agency is beyond the scope of legislative authority. The Department of Public Health is limited by law to delegating its authority only to certified local health departments and has not been authorized by the legislature to delegate any of its authority to any other body of government, including school districts. This is critically important, and it's so refreshing to see a judge actually undertake this analysis and look at the actual statutes to see if they say what these government institutions claim that they say. And that's not the case here. If the authority isn't there, they can't do it. And this judge concluded that this order delegating from the Department of Health, delegating its authority in public health matters to the Board of Education school districts is illegal. The court then looks at the actual emergency rules themselves from the Board of Education. And again, reiterates the notion that masks, tests, and vaccines were a form of modified quarantine before this change that was implemented pursuant to these emergency rules. People had the right to object to these procedures. If they objected, they were afforded due process rights. Same thing with being excluded from school. That's a form of modified quarantine, and it was considered a partial limitation of freedom of movement or actions, and thus people could object to them, and they had due process rights. It's difficult in conversation to emphasize as emphatically as it should be emphasized how problematic it is for a state institution to remove these types of protections through an emergency mechanism. Okay? That's what many of these governments have been doing. They have been removing the due process protections that people have from government encroachment under the guise of, well, it's an emergency or public safety. We need to do everything necessary to protect you. Therefore, we need to take your rights away in order to do that. That's asinine. That is absolutely preposterous. And you should always question and apply a very, very, very heavy and healthy dose of skepticism to any government proclamation that says, in order to protect you, we need to take away your due process rights. So the judge here, in looking at the Board of Education's rules, writes, the court has left the question, what authority the board has to mandate a vaccine that has not even been mandated by the Department of Public Health. So that goes back to the same issue. The authority for public health measures lies with the Public Health Department in Illinois, not with the Board of Education, not with the school district. And the judge here is questioning, how in the world can a school district require a vaccine in order to be present in a classroom when the Department of Public Health has not mandated that vaccine. They can't. They don't have the authority to do that. The institution with that authority hasn't done it. The court goes on to write that, one agency within the executive branch, the Department of Public Health, cannot delegate authority to another agency within the same executive branch, absent legislative authority. Nowhere in the school code did the legislature grant the board or the state superintendent the authority to order or mandate vaccines and tests. So the governor's mandate, concludes this judge, is meaningless, and the board's emergency rule exceeded its authority. That is a wonderful conclusion, and it really drives home the point here. If the authority isn't there, then whatever measure is implemented is meaningless, it's illegal, it's void. It has no, it cannot be enforced. It is completely meritless. The judge spent some time going through whether or not these state agencies complied with public notice and comment requirements. I'm going to gloss over that a little bit here because that can be somewhat dense. Basically, an agency has to, whenever an agency issues a new rule, they have to undertake what's called the rulemaking process and issue a public notice and have hearings and all this and take comments from the public. But I'm not going to spend too much time on that here. I want to go to the sections, a couple of points I want to make concerning the authority of school districts that the court addresses. So first, the court notes that no school district had the court could not, for whatever reason, this issue wasn't before the court. It was really the authority of the governor, the Department of Public Health, and the State Board of Education. Whether or not school districts had the authority to do this, the court couldn't decide that, but the court did conclude that no school district had policies in effect that predated COVID-19 and the governor's mandates that required masking, testing, exclusion from school, quarantine, isolation, or vaccination. So the court, absent these emergency rules, which the court has called into question their authority, the court points out that school districts never had the authority to do any of these things in the first place. So that's important to remember here going forward with this case. But the court obviously cautions that those issues are not before the court at this time. Then there's an issue about whether the teachers' unions are up in arms over this, like they have been with a lot of these issues. In many of these instances, teachers' unions have essentially forced school districts to implement a wide variety of COVID measures, including masking and vaccination, and they force school districts, to agree to these in a memorandum of understanding that they usually attach to their collective bargaining agreement. And they did the same thing here. There are apparently CBAs at issue here that require these provisions. So some teachers' unions are still trying to force school districts to keep these measures in place. The court, for whatever reason, couldn't address that issue, and this issue wasn't before the judge. And so the court essentially punted on that issue here, but that will probably come up before this judge at some point. But that could not be decided here. But I saw some posts on Twitter where teachers' unions were stating that they were going to continue, in some school districts, pursuant to their collective bargaining agreements and memos of understanding, they can continue to implement these measures in light of these agreements. And that's probably why they are saying that. The last issue I wanted to address, it's on page 21. So one of the requirements in getting an injunction, so what the parents and the teachers did here in this case was they filed a complaint, but they also filed what's called a motion for an injunction, a motion for a preliminary injunction, or this is a temporary restraining order. So they did a motion for a TRO, a temporary restraining order. That is an order at the beginning of the case that requests that the court either tell somebody either to do something or not do something. So in this instance, they're requesting that the court prohibit the enforcement of these rules requiring masking and vaccination and exclusion from school if you don't test and this and that. The reason you want an order like that at the beginning of the case is because you don't want to wait for a trial, which could take, depending on the state, depending on the court system, could take a year, 18 months, 2 years. And hopefully by the end of that process, all of this would be moot, so it doesn't make sense to wait for that, right? So the plaintiffs in all these cases are requesting emergency relief at the beginning of the case. Now, in order to do that, it's not sufficient just to show that you're likely to win, or that you're going to win on the merits of your claims. You have to demonstrate what's called irreparable harm. You need to show that the measures you're challenging will cause you harm and continue to harm you if you don't get the relief that you want. So here, a lot of people think that, well, showing harm, I need to show that these masks are harming my kids, or you need to show that if I have to vaccinate my kid, they might suffer some adverse event, and we all know that there's a lot of data on that right now in the VAERS system and elsewhere. But that's not, you don't really even need to go into those topics, because those are very emotional topics, and you need experts for that. But the other form of harm that's at issue here is the violation of your rights. The violation of your statutory rights, the violation of your constitutional rights, and specifically your due process rights. That is sufficient to show harm. The cases, courts from the past have all concluded that when your statutory or constitutional rights are violated, that is sufficient for a showing of irreparable harm. And that's what the judge concluded here. The injury to a plaintiff must be in the form of a plaintiff's legal rights being sacrificed if plaintiff is forced to await a decision on the merits. And the court continues, the legal rights being sacrificed are the rights of due process under the statute at issue, which are further provided under the Illinois Administrative Code. The court finds the plaintiff's legal rights to procedural and substantive due process are being sacrificed each and every day. Now, this is not, the plaintiffs did not bring constitutional claims here. They brought a statutory authority claim, okay? And this is the argument that there's a trend in all these cases, in all these decisions. The cases that have been reported that have halted mask mandates, vaccine mandates, those decisions have all been based on the lack of authority of the governing entity that issued the mandate. This is the same argument in this case that these plaintiffs brought. And the court concluded that not only did they demonstrate that there is no authority for these mandates in these emergency rules issued by the governor and these administrative departments, but the plaintiffs demonstrated irreparable harm by showing that their rights under these statutes were violated. Okay? So these are not constitutional claims. Illinois has done the somewhat unique, they've undertaken this somewhat unique measure of codifying people's due process rights into these statutes. And so when you hear due process, when you read due process in this decision, that's not referring to a constitutional claim. It's referring to a statutory right that's been violated. That's the important thing here. The court continues, due process of law is a guaranteed right to the plaintiffs under the Illinois Constitution and has been specifically codified for circumstances such as these under the applicable statute. When a right such as the one being violated here is alleged, irreparable injury is satisfied. So the court found that plaintiffs not only showed that they would likely succeed on the merits of these statutory challenges to these measures, but have also demonstrated irreparable harm, and for those reasons, they met the requirements for a temporary restraining order, and the court issued it. So there's a lot more in this decision, but I don't have time to go through all of it. I wanted to highlight those issues and those sections. The case is Julianne Austin versus the Board of Education. There are many other plaintiffs. There are several cases here that were consolidated. It was issued on Friday. This is a very, very good decision. It touches on several issues in a very in-depth way. This judge did a very, very good job of parsing through the different claims and trying to understand where the authority comes from for these emergency rules. And the court correctly found that there is no such authority, and that these state officials are trying to, they're trying to get creative and crafty with continuing to assert their control over the populace under the guise of public safety. But this judge drew a line in the sand and said, nope, you can't do that. It's a great decision. Read through it, and I hopefully we're going to see more decisions like these coming down the pike if a lot of these measures in many of these blue states remain in place. Thank you for taking the time to go through this with me. Again, great decision. You should read it. I'll link to it in the podcast notes and in the description.